It's been a couple of days now. Opportunity for you to digest, and all of us to digest, the ruling from the ICJ, the International Court of Justice. I want you to talk about the ruling, but can you also just give us a sort of a thumbnail? Like, what is the ICJ? What kind of authority they have, and under what auspices was it created?
Okay, so the ICJ it's another word for the World Court. And it's a branch, the judicial branch of the United Nations. And so what it deals with is cases that are between different states where there are legal disputes. And it also deals with questions that are put to it, legal questions that are put to it by the UN General Assembly. So there are two types of cases that can come forward: a state-to-state case, and another type of case, I'm being very general here, but another type of case where there is a question about the legality of something. And so this court is the highest international court. Its rulings are final. And under the rules of the ICJ, all of the nations have to abide by the rulings of the ICJ. And if they don't, they can go to the United Nations Security Council to get some enforcement mechanism. So overall, it's really just the World Court.
Okay, and there are 17 justices that adjudicated this case brought by South Africa, or are in the process, I should say, of adjudicating it, because this was a sort of almost a preliminary judgment. How are those justices picked, and do they rotate? What are their terms, et cetera?
Yes. So the justices are picked through the UN General Assembly, and they have to be confirmed. Their term is for a period of 5 years, and they can be reappointed. So on February the 6th, 5 of the 15 judges are going to be retiring. It's actually really only 4, because one of them has been reappointed for yet another term, including the judge who is from the U.S. The person who actually read out the decision. She will be leaving the court on February the 6th.
This is Donahue, right? She was a former State Department
former official. State Department. Yes, yes. And so it's not a political court. It's a legal court, and it's supposed to be treated as a legal court. Now, there's only 15 judges, by the way. There are then, when there's a dispute involving 2 countries, then they also appoint a judge from either of the 2 countries where there's a dispute. So in this particular case, because it was South Africa versus Israel, a South African ad hoc judge was appointed, and an Israeli judge was also appointed on an ad hoc basis. And this is important because when you look at how this ruling came out, you saw that of the permanent judges, of the judges who are not ad hoc, 14 of the 15 ruled in favor of South Africa. I mean, that's the equivalent of a slam dunk, really.
Were you surprised? I mean, I want to go through obviously what they found, but I mean, in all of the pre-judgment analysis I heard, even regardless of where these people were in terms of what they thought the outcome should be, I didn't hear anyone even come close to predicting that we would see 15-2, 16-1 on these really significant questions and rulings. Were you surprised by the unanimity?
No. And the reason I wasn't surprised is because the South Africans did a fantastic job presenting their case, and even worse, the facts really speak for themselves. I live in Haifa. I'm 180 kilometers away from Gaza, and I used to live in Gaza. I have many friends in Gaza, and every day we see the images of what Israel is doing in Gaza, and you hear the statements of of UN statements of what's happening there, of the dire situation. But also from my standpoint, I also hear what Israeli politicians are saying on a daily basis. And so it wasn't at all surprising for me that the court found the way that they did. And it's not at all surprising that they found with the unanimity that they did. I wasn't at all surprised by the Israeli judge. Having seen him operate here in Israel, I know the way that he acts. And so I wasn't at all surprised, because the situation really is dire. And South Africa presented a very strong case, sadly, because the facts are so strong.
Walk us through now walk us through what the court could have ruled at this time, because ultimately the question of whether Israel is engaging in genocide is going to take years to deliberate. But this ultimately was almost like a preliminary injunction type of hearing. And so what could they have decided? And then tell us what they ultimately did.
Okay, so I can tell you what they couldn't have decided. And that's, I think, the thing that has been bothering people the most, and that is ceasefire. They couldn't come out and say ceasefire. Why? Because that can only come at the end of a hearing, at the end of a determination as to whether Israel is carrying out a genocide. At this point in time, what South Africa was saying and what they were seeking was, they said, there is enough information out there to say that that there is risk of genocide. And so if there is risk of genocide, the world community must act in order. What they could have done, and what they actually did do, is to order measures to prevent genocide. And that's why they listed out 5 main measures that must be done. The first one is they ordered the Israeli government to do everything in its power to prevent genocide. They then ordered this be translated to the military as well. They then ordered that evidence be preserved. They ordered that effective humanitarian aid be provided on an urgent basis. And they ordered that those who are making genocidal statements face some level of prosecution. And so 4 of the 5, Sam, the first 4 that I enumerated, 4 or 5 that I listed, is really a ceasefire, but by a different name. Ceasefire is something that is applied when there's war. Preventing genocide and listing out what needs to be done to prevent genocide is what's done when there's fear of genocide. And that's what they ordered. You know, it's also important to bear in mind that in other similar cases like Myanmar, the court came to a similar decision, also did not order ceasefire in that context either. So what they did is the order that it issued is so wide-ranging that the world should be reading this as a ceasefire. Now, more importantly than that, genocide isn't just like other international wrongs or other wrongs that are committed by states. Genocide is a wrong that's committed by a state that requires that all of us act individually and collectively. So unlike in other disputes where there might be war doesn't require us to individually and collectively stop war. But genocide does, because it's considered the worst of crimes in the international legal system. And so this order doesn't just bind Israel. It also becomes imperative upon everybody, like all countries, to make sure that genocide gets prevented.
I want to get to that third-party obligation and sort of the legal basis of that, because presumably it's like if you're a member, if you subscribe to the authority of the ICJ, that there are certain obligations that you in that subscription that you assume. But let's get to so that there's clarity. I think there is often the concept of genocide is misunderstood as being specifically about,
Killing.
a diminishment of numbers, period, end of story. You need to kill everyone who's associated with a group for it to qualify as genocide. And that's not the case. Can you give us the legal definition of genocide? And it is one that came in the wake of the mass murder of Jews during the Holocaust, and was formulated in 1948 in a specific genocide convention. Can you outline those to us so that people can understand the threshold that the court was addressing?
Yes. So people often assume that genocide equals killing. And I understand why people view it in that way, but that's not what genocide is. So genocide it has to have two elements to it. The first is that there has to be an intention, and I'll talk about that in a second. But then coupled with the intention has to be something that a state is doing. And the something has to be acts that lead to killing members of the group. I'm just reading this off so that I don't get it wrong. Causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life that are calculated to bring about its physical destruction in whole or in part, or imposing measures that are intended to prevent birth within the group. So it's this idea of, it doesn't just have to be killing, but it can be the destruction of the group through bodily harm, the destruction of the group in terms of preventing birth. It's the physical harm. And as I said, there's two elements to it. There's the actual act, but then there's the intention. And in most genocide claims, it's hard to prove intention. In this particular case, that wasn't a hurdle, because on all levels of society, of government, excuse me, as somebody who lives here, I can tell you, we've heard it day in and day out since October the 7th. And that was really important for the court, because the court actually read back many of the statements that have been uttered. And these are, again, uttered not by a soldier in the field, but by high-level officials who can influence the actions of soldiers. And in this particular case, they read out the statements from the Minister of Defense, who talked about cutting off fuel, water, electricity, and food supplies. The president, who said that there were no innocents in Gaza, and another minister who also issued some quite genocidal statements. And in sum total, they said, we've seen both the intention and the acts. And it's not just the killing of, we're now close to 30,000 Palestinians that we know about.
Right.
But if you couple the 30,000 with the more than 70,000 who've been injured, very seriously injured, plus the destruction of Gaza, it makes the case.